screen goes dark and the world won't start, you know who to call, yeah. That frozen screen, 3 days now and you're losing your mind. I see it typing but nothing's working right. Daniel's got that look in his eyes. From sunrise to the end of the day, you're always fixing what's broken away. Why do you always stay when everyone else would walk away? Cold while you run diagnostics, explaining every step like I'd understand. Your hands move fast across the keyboard, magic, making sense of what I can't comprehend. From sunrise to the end of the day, you're always fixing what's broken away. Why do you always stay when everyone else would walk away? Parts. Maybe it's about the way you see. Every problem has a beating heart. You won't give up on me. Now the screen's alive and everything's running smooth. You pack your tools with that quiet smile. I know tomorrow when something breaks loose, you'll be back here in a little while. That's why you always stay when everyone else walk away. That's why you always care. That's why you're always there. The screen goes dark and the world won't stop. I know who to call, yeah.
All right, welcome. Today is Tuesday, which means it's J. Cedric Simpson, the Honorable J. Cedric. I'm tongue-tied today. It's Judge J. Cedric Simpson's courtroom. So let's get this started. Make this bigger. And away we go.
Andrew Joe is appearing on behalf of the people, Your Honor. Good morning, man. Please, Honorable Court, Kareem Johnson, on behalf of Mr. Buckman, Mr. Prochi, and seated to my right.
State your name, sir. Thank you. All right. Date and time set for preliminary examination. You may proceed.
That's correct, Your Honor. The people are ready to proceed. We intend on calling one witness, and the people call their first witness.
You may.
We would call Amy Hudson to the stand.
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God? See, state, spell your first and last name for the record, please.
My name is Amy. It's A-M-E-E. My last name is Hudson. A-S-O.
All right. You may inquire.
Thank you, Your Honor. And just one other matter.
My officer in charge, Deputy Von Heath, is present in the courtroom. He's the only other witness I have present. I don't intend to call him, but he is present.
All right, good.
Miss Hudson, directing your attention back to the date of April the 1st of this year, 2025, were you in this courthouse testifying in a preliminary examination on a different matter?
Yes,
Okay. And was that in this very courtroom, courtroom C?
yes.
Okay. And who was the judge at the time? Judge Washington? Okay. And
What if you were prepared for all those interview curveballs?
did was the defendant in that case, based on your understanding, Ms. Hudson, Mr. Buckner?
Yes.
Is he present in the courtroom here today?
Yes.
Can you identify an article of clothing that he's wearing?
He's wearing a black.
Okay. Your Honor, may the record reflect in-court identification of the defendant?
Without objection, record show so reflect.
And I don't want to get into the facts of that case, but you were some sort of witness in that criminal case. Was that a criminal case?
Yes.
Okay. And you were a witness in it?
Yes.
Okay. And had you testified before Judge Washington in that matter on the date of April 1st, 2025?
Yes.
Okay. At some point, were you done testifying?
Yes.
Okay. After you were done testifying, what did you do?
I went and sat back down while they called up the next witness.
Okay. Where did you sit down?
I sat about where I was sitting when I stood up today, maybe one row up.
Okay. So we're making a transcription of this. So I'm going to have to be.
It's on the right-hand side, probably the third row back.
You're pointing in the courtroom. So you remained in the courtroom?
Yes, I remained.
Okay. So you sat down in what we would call the gallery of the courtroom from where you are sitting in the witness stand on the right-hand side. And you said about the third row back.
Third row back.
Okay. And you did that while another witness was testifying. Okay. And at some point in time, did that witness stop testifying?
Yes.
Okay. What happened after that witness stopped testifying?
The judge asked for some more information and then she called for a break.
Okay. The judge stood up to take a break? Okay. Is that a yes?
Yes.
Thank you.
I'm sorry.
It's okay. And what happened when the judge stood up to take a break?
When they called the court for recess, he was on the left-hand side.
Who is he?
Was on the left-hand side. He stood up. He was around two people that had already started to be in the row.
I'm going to just stop you right there. So you've said the left-hand side. That would be the left-hand side of the courtroom from where you are seated in the witness stand today.
Yes.
Okay. That would be the side that the defendants normally sit at?
Yes.
Okay. Where was the defendant seated?
He was in the first row back.
In the gallery?
In the
Okay, so he was not seated at counsel table?
No.
Okay. So the judge got off the bench and exited the courtroom?
Yes.
Okay.
Yeah, the judge, she did not exit the courtroom right away. She stood up, as they were calling. There was two people up front talking to her. And then when she got done speaking to them, that's when they called the recess. And he stood up.
He being the defendant?
Yeah. Went towards the middle. There was two people already going to go to exit. He waited until the sound went out.
Okay, when you say how do you know he waited until the sound went out?
Because he turned around and he looked. He stopped.
Objection, speculation.
I'm gonna overrule the objection. I'm gonna let her.
He stopped. He looked back. The minute
Hold on. Hey, look back at
at
where?
the screen. He looked back at the screen to make sure that the judge.
I'm gonna just,
Okay.
I'll stop you there. We're gonna unpack this a little bit. And Judge, I understand the court's
Okay.
concern. So you observed the defendant you said he stopped. Where did he physically stop?
In the middle.
In the middle aisle?
In the middle of the aisle.
Okay.
Yeah.
Where was he in the middle of the aisle, close to what we would call the bar or close to the back door of the court?
He was in the middle, like closer towards this side of
You're motioning the right side.
the right side.
Okay.
Yes.
But I'm asking you, distance-wise, was he in this area or was he in the back part of the
No, he was closer towards the
front? Okay. You are still, fair to say, you are still seated in the third
I'm
row
still seated.
on the right, your right side of the courtroom.
Yes.
Okay. When the defendant stopped, is he looking at you or is he looking somewhere else?
When he first stopped, he was looking like straight ahead.
Straight ahead.
And then he
And
turned
Straight ahead toward,
towards the exit door.
Towards the exit door?
Yes.
Okay.
And then when he stopped, he turned around and he looked.
And in what direction, when he turns around and looks, in what direction is he looking?
He's looking to see if the judge is.
I'm not, and so that's, I'm not asking you, you can testify to things that you see, things that you hear, things that you witness. You can't testify to what someone else is thinking,
Right.
okay?
No, he
So,
turned in the direction as to where the judge stand is.
okay, so just so we're clear, the defendant was looking towards the back doors of the courtroom. He then turned around and is looking in the direction of where the bench and the TVs are.
Yes.
Okay.
Yes, the bench and the TV.
At some point, does he then turn back around to look towards the back door?
Yes, he does.
When did he do that?
The minute the screen started making that sound.
Like a whoosh, white noise sound?
Yes.
Okay.
Yeah, like
And
it's no longer.
And I will direct your attention right,
okay, go ahead.
I'll direct your attention right now. There are screens on in this courtroom. Did you see those?
Yes.
And they're depicting the court and yourself in the witness stand. Is that correct?
Yes.
Okay. Did the screens look like that when the okay. What did they look like if
They
you look?
were like, as if cable went out, they were, there was nothing there. It said private.
Okay, it said private.
There's a black screen with private written in white.
Yeah,
Okay.
yes.
At that point, once the screens changed from showing the video of the courtroom to this private, what did the defendant do?
He walked on to the right-hand side, stopped to where I was sitting and made verbal threats.
Okay, he said something to you?
Yes,
What did he say to you?
he called me.
I'm gonna stop you right there.
Yes,
Hold on a moment. You mentioned something and I just need to clarify this. You said that there was static.
yes, sir.
What was that you're talking about?
There was no more pictures showing. It was just a like when you call up the lawyers to speak to you,
Mm-hmm.
the screen makes a noise. It makes it makes a noise. I don't know how to describe it. It's not it's not a silent noise. It makes a noise to where it's not recording anymore. Do you want me to sit down so you can turn it off?
No,
Okay.
pretty much here every day. I'm just trying to figure out what you're talking about. You're saying it made a noise.
I put this in my ears, and I haven't asked anyone to repeat themselves in over 3 months. This is magic. I wish.
Yes, the screen went blank, and it's not like it's crushing out a noise. Like there's a noise
Coming out of the speakers.
Yes, coming out of the speakers.
Was it a constant noise?
It started, and then I'll be honest, I don't know if it was on.
Gotcha. Okay, just one other thing.
That's fine.
When you said Judge Washington was talking to two people,
Mhm.
was she talking to two people in front of the bench or two
Yes.
people behind the bench?
No, two people in front.
So she was speaking to two people in front of the bench. All right. At the point at which she's doing that, can you hear that conversation?
No,
Okay, at the point at which she's doing that, do you hear anything in the courtroom?
no. I mean, I can hear people talk, but not up front. I mean, just what, people may be saying as they're sitting on the gallery.
Right, but do you hear anything else?
No,
Okay. And she had that conversation and then turned around and left.
yes, yep, they call.
At the point that that happened, what was on the screen?
Before, when she got done speaking to them,
Not as she's talking to them,
it's,
what's on the screen?
there's nothing on the screen. And then she got done speaking and the video came back up before they called recess.
And when you say the video came back up, the video like it is right now?
Yes, and it
Okay.
just showed her on the bench. There was no one on the stand.
Okay, go ahead.
So at some point, as we've discussed, the defendant then turns and is walking, now facing back towards the back door,
Yes.
which would also be in the direction that you are in relation to the defendant.
I think he's just recapping what she's saying, so I'll overrule it. Go ahead.
Yes,
Okay. And you had previously said the defendant said something to you.
yes.
Okay. What did he say to you?
He called me a lying bitch and told me that that he was gonna get even, he was gonna get me. That was the last thing he did. He was gonna get me.
Did you say anything in response to that?
No,
How did that statement by the defendant make you feel?
threatened.
After he made that statement to you, where did the defendant go?
He turned around, looked back one more time.
I'm going to stop you there just so we're clear. So the time he's talking to you, is the defendant looking towards the back of the courtroom or the front of the courtroom?
He's looking he's looking at me.
Right.
At the exit.
Okay, so he's facing away from where the judge would sit.
Yes,
Okay. After he makes that statement, you said he turns around.
yes.
Okay. When he turns around, in what direction is he now facing?
He's facing back towards the front where the judge would be sitting for
Okay.
this area.
At the time he turns around, is the judge on the bench?
No,
Okay. If you recall, at the time he turns around, who would be on, and I'm motioning on the other side of the bar, who were there attorneys or people present?
yes, yeah,
Okay.
his lawyer was still on the left-hand side. You guys are still on the right-hand side.
You guys being someone from the prosecutor's office?
Prosecuting, yes. And there was one officer also on the right-hand side, and there was one officer sitting out in the gallery, like 2 up from me.
Okay. So the defendant makes a statement to you. He turns around and he's now facing back in the direction of where the judge would sit. And what happens next?
The minute he saw that his lawyer was coming out, he turned around and took out the exit door.
Okay.
So again, speculation of what my client saw.
Okay. I would agree. So
Let me ask-
his lawyer, what you saw, ma'am, was his lawyer starting to leave and then he left.
Yeah. the minute
That's
he
that's
saw-
what you, no, that's what you saw.
Yes,
Okay, thank you. I think that corrects it. That's what.
Um,
Go ahead.
And did you remain seated in the gallery of the courtroom or did you exit the courtroom at that point?
I remain seated.
Okay. And at some point after this fact, did you bring what had happened to someone else's attention?
Yes,
And who was that?
it was one of the police officers.
One of the police officers present in the courtroom?
Yes.
Okay. After you made contact with the police officer, did you have any further interactions with the defendant, Mr. Buckner? Okay. Certainly not in the courtroom,
Right,
correct?
right.
Okay. Anything in the hallway of the courthouse?
No,
Okay.
no.
Hey, one moment, Your Honor.
Ma'am. While you do that, ma'am, you said you were seated in the third row. How far in on that third row were you?
Right there where the gentleman is with the black sweatshirt.
So you were seated on the end
Yes.
toward the aisle.
Yes.
Okay.
I have no further questions, Judge. Thank you.
Cross-examination.
Okay, ma'am, so you were here to testify, and if you remember, was that in case number 25 FB 1106, if you know?
I have no idea.
Did you get a subpoena to come to court and testify in that
No.
case? In that case?
I did not get a subpoena.
Okay.
They asked me to come and testify.
Now, it's my understanding that you're indicating that you are
Picking
sitting
him up. Picking him up.
in the gallery courtroom right here.
Wow. Okay, yeah, gotcha.
Is that correct?
Yes.
And you said that there's a member of law enforcement 2 rows up, sitting right here, where there's an individual with a sheriff's shirt.
Yes.
And your testimony to Mr. Buckner comes down the hall, the aisleway, stands at that same pew where the law enforcement officer was and issued a threat to you, which would have been within 15 feet of the law enforcement officer.
I never said that. I said he stopped at where I was sitting and said something to me. I never at any time said anything that he stopped where the police officer was sitting at the pew.
So when he stopped, he was at your row,
Yes.
Picking him up.
but there was still a law enforcement officer 2 rows up.
Yes.
Was there other law enforcement officers in the courtroom like there are today?
One sitting up in the corner, up here on the right-hand side, where the gentleman is with the glasses.
When any of, I'm sorry,
Sitting where?
The gentleman with the glasses over here?
Mr. Bird?
Yes. That's where the other.
Oh, on this side. On this side?
On this side.
On the right. Okay, go ahead. Go ahead, counsel.
when this statement was allegedly made, none of the law enforcement officers in the courtroom jumped up and said anything?
No.
Now, you indicated that after you testified, you stayed in the courtroom.
Yes.
Was there a sequestration order was there an order that you leave the courtroom after you finished testifying?
No.
Okay, so you heard the testimony after your testimony.
Yes.
On August 22nd, I told viewers that the road to artificial general intelligence was already.
Mr. Buckner's lawyer at the time challenged the accusations that you made regarding Mr. Buckner, correct?
In which case?
In the case you were there to testify about.
Your Honor, I would object to what that other lawyer did. That would be hearsay.
I'm not asking for
Well,
what,
she's asking, I'll overrule that. I mean, he's not asking what she said. He's just asking what her impression of what he did.
right.
So, go.
His lawyer in the case you were there to testify on was challenging you on the assertions, allegations you made about Mr. Buckner.
For that case?
Yes.
Well, I mean, I don't know if he was challenging me, he was just questioning me the same as you are.
And there was another witness that came up to testify after your testimony, correct?
Yes.
You heard that witness's testimony.
Yes.
You were there when the preliminary examination ended, correct?
Yes.
That Judge Washington, found that there was no probable cause that Mr. Buckner committed a crime. Correct.
I would object to the relevance of that.
Well, Your Honor, the relevance is they've charged my client with intimidating.
I'm going to overrule the objection.
Yep.
Go ahead.
Judge Washington found that there was no probable cause to believe that Mr. Buckner committed a crime after you testified, correct?
She also stated that it can be called back up if they get the proof that they need.
Okay, which is fair. All right. So after you made accusations about Mr. Buckner pointing guns at people, correct?
What does that have to do with this case?
Ma'am, I don't.
Answer the question, ma'am.
Yes, I did.
You made accusations that you saw him deliver crack from a great distance away? You didn't make the accusation? Did you make an accusation that you saw him point a gun at somebody?
Yes.
Okay. No further questions, y'all.
I have no redirect, Judge. Thank you.
All right. Ma'am, how long did it take you to report this to somebody?
Within minutes.
Where was Mr. Buckner when you reported this?
He had walked out of the courtroom.
How long after he walked out of the courtroom did you report it?
Within probably 2 minutes, if even that,
To whom?
to the police officer passing by.
Which police officer? Is that officer here today?
Yes,
Okay, and that's who you reported it to?
yes.
That interaction, and if you look back on the right-hand side where the gentleman seated in the black shirt is, you're saying that's where you were sitting.
Yes,
When Mr. Buckner came down the aisle, you'll notice that the back row is basically a handicap accessible row or a non-handicap accessible row. You see that where it extends out?
yes.
How close was Mr. Buckner to you when he's making these comments?
He was past where the gentleman is sitting with the black sweatshirt, and he was in between that row and the woman sitting right behind him. And he leaned back and
And he leaned back.
he looked, you know, yeah, turned his head back and spoke to me.
So he's, because that's a little bit different than what you told me before, because you're saying that he was where the gentleman seated in the black
Right.
is, he was past him toward the door.
No, right, there's right where he's sitting, right there, at that spot, right there. Like there's a spot, you know, where you, not where you would enter, but where would be if you're standing beside. So closer towards the opening of the back row.
So he's standing closest to the opening of the back row.
Right, but he's beside where the gentleman is with the black sweatshirt. And that's right.
But so he's over on that side of the courtroom?
Yes,
So ma'am, are you telling me he's no longer in the middle aisle?
no, he crossed from the middle aisle to stand closer towards the right-hand side. He's no longer in the middle. He's standing like as if you're having a one-on-one private conversation with somebody.
How loud were these comments you say he was making?
They were not very, I mean, other people were walking out of the courtroom. I could hear them, and it's not like he was screaming them. They were normal voices.
When you testified in the previous matter, was there a victim's advocate assigned to you?
Yes, there was a victim's advocate.
Okay, so after you testified, did you talk to that victim's advocate?
No. They asked me to just go sit into the courtroom.
I want to go back, ma'am. At the time that you say Mr. Buckner got up, what's on the screens in the courtroom?
The screen was still on to where you could see where the judge was sitting. And then she called for a conference. And then the screen went blank. And then the screen went back up to where you could see where the judge was sitting. And then she called for a recess.
And then what happened to the screen when she called for a recess?
And then the screen went blank. And said, you know, right, and it didn't show any pictures, didn't show any people anymore.
Prior to the judge taking recess, was it Mr. Buckner's other case that was being heard, the case that you were there for?
That case had been heard, and then honestly, another case was heard, there was a witness, but I think he was sitting out in the galley, and I think that they had started to call for another case. Because I don't think that.
Had your case that you were there on, had it concluded at that point?
Yes, because he was sitting out in the galley.
Okay. So then my question is that case had concluded,
Yes.
the judge had made her ruling.
No, she had asked for some more information, and they had set it aside for a minute and was gonna call it back up.
And so had they called another case?
Yes,
Was Mr. Buckner's attorney on that case?
no, he was sitting on the left side, where the gentleman is behind his lawyer right now where the glass is.
So he had moved back to the chair.
Yes,
But during Mr. Buckner's case, he was at the table with Mr. Buckner.
yes,
From that period in time, that case ending until the judge took a recess, approximately how much time was there?
Simple. I only pay $10 a month for my internet connection. Fast, unlimited, anywhere. Have you heard about Ryoko Pro?
Mr. Buckner, you said was in that first row, right?
yes,
How far into that first row was he?
like right on the end.
So he's right on the end, seated where I guess the young lady in the pink would be.
Yes, hi. I'm sorry.
Sorry to use people as props, but that's where he was sitting?
Yes,
Okay, so he's sitting right behind his attorney.
yes,
Okay. And then at some point he gets up
yes.
and walks back. Were you the only witness that had testified in that previous case?
No, it was me and one police officer,
Okay.
but I was the only.
Where was the police officer that testified?
He was sitting over, on the right-hand side where the gentleman is with the glasses.
Did he testify before or after you?
After me,
He testified after you.
yes.
Was there another witness then?
They stopped because the judge asked for information. So they were pausing it to see if they could collect the information that was needed to proceed with the case.
So just so I'm clear, you were the first witness to testify, right?
Yes,
The next witness was a police officer.
yes,
And all during that time, Mr. Buckner is at the table where approximately where he is right now.
yes,
Then at some point, there's a break. Mr. Buckner leaves the table
yes.
and is seated in basically the first seat in the first row behind defense counsel.
Yes,
Then another case is called,
yes.
right? And was it the attorneys? Was it the attorneys on that next case? Was that who the judge was talking to?
Yes. I don't know if it was it was someone from the state and then someone representing that person. So yes, that's who the judge was talking to.
They were the attorneys on the next case.
Yes,
Okay, and the judge spoke with them.
yes.
As the judge is speaking with them, what do you hear in the courtroom?
The noise coming from the speaker and
What noise?
whatever that noise is. I don't know how to describe it,
Okay,
but just so we can't hear what's being said up here at the bottom.
okay, so you hear that.
Yes,
At the point that you hear that, where is Mr. Buckner?
still seated.
Okay. The judge then leaves that session, gets up to walk out.
Right, but the screens turned back. When they went back towards their tables, the screens went back to where you could see the judge. And then they called recess.
All right. At the point that they call recess, where is Mr. Buckner?
That's when he stands up, goes towards the middle of it, and then there's two people. He goes, and then that's when he stops. There's two people getting out like in the next row.
How many people were behind Mr. Buckner in the gala?
honestly, I don't know. I mean,
How many people was there a person sitting behind you?
I don't think so.
Was there a person next to you?
No.
Was there a person in front of you? Which would have been in the second aisle?
I don't. If there was, I think.
Didn't ask that. Do you know whether or not, okay, do you know whether there was a person 2 aisles up?
Yes. that
Who
the
was-
police officer.
And how far over was the police officer? You're saying where the gentleman that just sat down in the blue tie would be? Mr. Warren Green,
No,
that's you.
further over. He's probably where the other officer is, if not closer towards.
So
the wall.
he's further over toward the wall.
Yes.
Is there anybody else in that row that you recall?
No.
Is there any, so where you are, you're saying there's nobody in your row?
Not that I remember, but not that I remember.
Behind you, you're indicating that there's nobody behind you in that row.
Not that I remember.
In front of you, the row would be directly in front of you. There's nobody in that row that you recall.
Not in front of me, there was someone down.
There was what?
There was someone down closer towards like where the gentleman is with the blue tie. There was 2 people right there.
There were 2 people right there?
Yeah. They weren't towards the edge, they were like in the middle down.
When Mr. Buckner allegedly makes those comments, do they turn around?
I was not paying attention. I just put my head down and just let it happen.
Council, council approach briefly. So what I'm gonna do in this case is, and I talked with council, I'm gonna take a brief break. Get some information, get it to council, and then, continue the hearing after that.
May this witness be excused or is the court obviously appropriate if the court wants to inquire based on reviewing the video?
Yeah, I don't want this witness excused at this point, because I may have questions and the video also may give rise to questions from, Mr. Johnson, all right? So we'll pause in this case. You may step down, ma'am. And I'll call you back up. And, court's gonna take a brief recess. And I know people want to talk to me, but court's gonna take. Sure, yeah, but court take a brief recess.
What's going on, everybody? Welcome to another edition of the Drive.
All right.
State of Michigan versus Lawrence Buckner.
Andrew Childers appearing on behalf of the people, Your Honor.
Good afternoon, Kareem Johnson, on behalf of Mr. Buckner.
All right. We had finished that witness. Do people have a motion?
And I guess just for clarification, I don't think we technically finished the witness.
That's true.
So if the court is satisfied, I have no further questions for that witness.
Okay.
No further questions, Your Honor.
All right. Very good.
We'll have no further witnesses. The people will rest.
All right. Any witnesses for the defense?
No, Your Honor.
All right.
Your Honor, at this time, the people would move to bind the defendant over as charged on the 1 count of witness intimidation based on the testimony of our 1 witness. Obviously, the court has provided both myself and Mr. Johnson copies of the video. Because our county issued laptops don't have CD discs, wasn't able to watch it myself, but I know the court has watched it, and I trust the court's judgment in reviewing and will respect the court's decision in that. And so, thank you.
All right. Stretch.
Your Honor, for the testimony, reasons stated on the record through cross-examination, and the video that I asked to be admitted as defense exhibit A, I'd ask the court to not bind this matter over.
All right. The court will admit without objection exhibit A. In this matter, the court was very specific in questioning Ms. Hudson with regard to where she was at particular times and the like, to try to get a sense and feeling as to where Mr. Buckner would have been at any given time. The long and short of it is, when I review the video, it is clear Mr. Buckner is not seated in the first seat. He's actually seated in the second row back. And he's sitting there. We can pick up Mr. Buckner, and I'm looking at it. When I time what portions of the video Well, let me make this clear. There are points at which, when the court goes into recess, there is no video. So in looking at it, the best the court can is to the timing of when the events would have occurred. It is clear we see Mr. Buckner in the courtroom at a particular point. No doubt. He's in that second row, sitting there. He's second row, basically second seat in. At the point at which Ms. Hudson indicates that this occurred, Mr. Buckner is not in the courtroom. And that doesn't mean that it may not have occurred at another point. However, the testimony that I have in this case, it couldn't have happened. Mr. Buckner would not have been in the courtroom at that point in time. So with that finding in the court having reviewed that, the court's going to find that there's no probable cause to bind this defendant over on this charge. These charges are dismissed. Thank you.
Chances are you or someone you know is dealing with the limitations of pain in our back, knee.
Court does call the case of People versus Melina Ramirez.
This is Public Defender Alexis Dirks-Whippen on behalf of Ms. Ramirez. Ms. Ramirez, can you please state your name for the record?
Melina Ramirez.
All right. And what are we doing on this?
Your Honor, I believe you should have a plea form in the file.
I do. The plea form indicates that the defendant will be pleading guilty to the charge of use of a controlled substance, a 1-year offense upon their successful plea to that charge count. Well, this says count 2, but I don't think that's what you mean. I think you're intending that count 1 would be dismissed.
Yes.
I'll make the correction. All right, count 1 would be dismissed. That's the court's full understanding of the agreement.
Yes.
Yes, Your Honor, and I would be making the request for immediate sentencing as well, Your Honor. I believe the people will be objecting to that, but that'll still be my request.
People would not be objecting.
They would be objecting, Your Honor.
Your Honor, that is correct. I do believe that it will be in this case to have some specification report. Ms. Ramirez is currently inside of OC. In this case, she is alleged of drugs, and so Your Honor, that deciding what the proper sentence would involve a pre-sentence investigation report. However, she is
With what end goal?
Your Honor, perhaps she needs some drug treatment. She's supposed to. My understanding is she's
Okay, you might be right, but the problem is she's in the custody of MDOC. I could order whatever the heck I want.
My understanding is she's actually supposed to be getting released for parole. That may be incorrect, but her release date was supposed to be February, but she had this case, and so I think she's actually getting out.
And Your Honor, if I may, so that's my understanding was she was supposed to be released in February. She's been flopped by the parole board. However, this offense is back from October of 2023. And since then, Ms. Ramirez has gotten treatment in the prison, and she has been engaging in substance abuse classes since. So I believe for those reasons, she should get immediate sentencing.
Okay. Mr. Ramirez, can you raise your right hand? Do you solemnly swear or affirm that testimony you're about to give will be the whole truth and nothing but the truth, so help you God?
Yes, sir.
State your name for the record, please.
Melina Ramirez.
All right. Mr. Ramirez, it's the court's understanding that you're going to be pleading guilty to the charge of use of a controlled substance. That's a misdemeanor. It's punishable by up to 1 year incarceration and $2,000 fine plus court costs. You understand that?
Yes, Your Honor.
All right. And understanding that, do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty, Your Honor.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
All right. Did she execute this or you on her behalf?
Your Honor, she did execute this. I was
All
able
right.
to go over with it in person.
Got it. Mr. Ramirez, you signed an advice of rights form, is that correct? All the MDOC dropped. Okay. Now, that's good. They must be having some problem. I'm gonna have to pass them out.
Understood, Your Honor.
Court does call the case, People versus Demetrius Job.
Good morning, Your Honor. May it please this honorable court, David Burgess on behalf of Demetrius Job, who's approaching, Judge.
Can't get past Mr. Caldwell.
The wall of people back there, Your Honor.
Your name, sir?
Demetrius Job.
Thank you. You're requesting an adjournment.
2 weeks if possible, Judge. I just got retained. I need discovery. I spoke to Mr. Kennedy. I don't believe there's an objection.
No objection.
Probable cause conference will be adjourned to September 11th, 2025, 9 a.m. Bond continued.
Judge, could I address one aspect of bond real briefly? Your Honor, I spoke with Mr. Kennedy. My client is currently on a GPS tether. I understand the serious nature of the charges in this case, but he has no prior record. Judge, he's 51 years old. He is actually on house arrest, but I'm asking the court to consider removing the tether provision. There's a no contact that the incident allegedly occurred at the prior place of employment that my client's no longer allowed to go to. I believe that's where the complaining witness resides. So I don't know if the people take a position, Judge, but I'm asking the court to consider removal of the tether. If not, then a removal of the home confinement provision, Your Honor.
And I would defer to the court, Your Honor, as you think, so long as the no contact order is in place. I'll be able to go back to the residents of this case. So that's really all I'm concerned about.
Has the victim been spoken to about this?
No.
Are they the alleged victim in this case in the same area?
Still at the same
Facility.
That's my understanding.
Yeah, if you have to be allowed in and out, Judge, it's
If you frequently need to go to the bathroom late at night, we recommend eating 2 pieces daily. If you need to visit the bathroom
assisted living place.
At the 100 South Board?
That's correct, Your Honor.
Yes, Your Honor.
Where she works?
Resides, Judge.
Request for removal that are tethers, then by default in the home confinement would be removed.
Thank you very much, Your Honor.
Bond will continue in all other aspects.
All right, thank you, Judge. Thank you, sir.
Court calls case People versus Stephen Bauer.
Ready, Your Honor.
Your
Good morning again, Your Honor. May it please this honorable court, David Burgess on behalf of Stephen Bauer.
Your name, sir?
Stephen Bauer.
Likewise, you're asking for an adjournment.
Yes, Your Honor. Same 2-week adjournment if that's okay with the court.
Probable cause conference September 11th, 2025, 9 a.m. Bond continued.
Thank you very much, Your Honor.
Thank you.
Nice talking to you.
Your court does call the case People versus Sean Brown. The PD case, Ms. White.
Sorry, here's the name. Assistant Public Defender Sandra White on behalf of Sean Charnley.
Right, what are we doing?
Your Honor, we are going to waive the circuit court so that he can get a global resolution with his other cases. I need to get the
Sir,
paper.
is that correct?
It is.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
I do.
And you understand you'll not have that here and you'll proceed to circuit court for further resolution.
I do.
You'll also waive it, right?
Yeah.
Preliminary examination having been waived, defendant is bound over to circuit court on both counts. Ms. White,
Yes.
as to the arraignment,
Oh, we stand mute.
defendant having waived formal reading, standing mute to both counts, court will enter a not guilty plea. Pretrial in this matter will be set for September 11th, 2025, 1:30, Judge Slay.
Thank you, Your Honor. We'll have to,
Bond continued.
I don't see that paperwork. We'll have to get it to you.
Thank you, Your Honor.
Thank
Court does call the case People versus Taylor Adams.
An Assistant Public Defender Jay Ballinger on behalf of Mr. Adams.
Your name, sir?
Taylor Adams.
Thank you. Requesting an adjournment?
I am, Your Honor, a brief adjournment so that we can finish the negotiations on this matter.
Probable cause conference will be adjourned September 18th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor. Thank you, Your Honor.
Court calls case People versus Carlton Cross.
An Assistant Public Defender Jay Bellinger on behalf of Mr. Cross, who approaches.
Yeah, Cross. Thank you. Requesting an adjournment.
I am, Your Honor. We are actively working on getting Mr. Cross into treatment for consideration of an offer.
2 weeks work.
I think it does.
Without objection, probable cause adjourned to September 11th, 2025, 9 a.m. Bond continued.
Okay.
That's both, man.
I'll continue working on getting you out of here, okay?
Court calls case People versus Tanya Hall.
Government for the people, Your Honor.
Are they back in?
Morning, Roger Cole on behalf of Miss Tanya Hall. Tanya, state your name for the record.
Tanya Hall.
Judge, I met with Miss Hall yesterday at the Delana Center. We went over the plea agreement. She understands fully she's going to be pleading to the amended charge of use.
I have a plea form that indicates the defendant will be pleading guilty to the charge of use of fentanyl. That's a 1-year offense. Upon her successful plea to that charge, count 1 would be dismissed. The box regarding a sentencing judge waiver is not checked. You've gone through that with her?
There will be a different judge sentencing you. You don't have an objection with that, do you?
No.
I'm sorry, Your Honor. No, she has no objection.
May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Tanya Hall.
Ms. Hall, it's this court's understanding you're going to plead guilty to the charge of use of fentanyl. That's a
Yes.
misdemeanor, punishable
Yes.
by up to 1 year incarceration and $1,000 fine plus court costs. You understand that?
Yes.
In understanding that, you still wish to plead guilty?
Yes.
I will also advise you on the record that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. You understand that?
Yes, sir.
All right. And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights for me today or previously. Is that correct?
Yes.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you're giving up those rights as well as all the rights on that form.
It says you're giving up the right to have a trial, that's all.
I understand.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily?
Watch what eggs do to your knee pain.
You see this egg? Well, there's.
Yes, sir.
Of your own free will.
Yes.
All right. You have any questions regarding any of those rights?
No, Your Honor.
I think you looked at, I'm trying to recall. Paragraph 5, those are your rights which are part of the trial. You understand by pleading guilty, you'll be giving up those rights. It's all the rights on that form.
You're giving up the right to trial.
I understand.
You understand you're giving up your right to appeal of right.
No.
No, he's saying you're giving up the right to appeal.
Oh, yeah.
Are you on probation?
No.
On parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
and of your own free will,
Yes.
and because you believe that you're guilty of this offense?
Yes.
On the date of July 3rd, 2020, at the location of Ridge Road, Ypsilanti Township, Washtenaw County, State of Michigan, did you have a controlled substance in your possession?
Yes.
All right, that being fentanyl?
Yes.
Did you know you had the fentanyl?
No.
Did you know you had?
Well, yeah. Oh, yeah. I'm sorry.
Judge, it was she realized it was in her system.
I'm sorry?
She had it in her system, so she knows she had it prior to using it. I've explained that to her.
Okay, so you had used the fentanyl?
Yes.
Did you know what you were using was fentanyl?
Yes.
Got it. Ma'am, I do have to advise you that if I accept your plea, you commit misconduct between now and the time of sentencing, that you would not be entitled to withdraw your plea, and any evaluation or sentencing agreement, the judge would no longer be bound by. You understand that, ma'am?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court rule? Would it
Your
be
Honor.
proper to accept this plea?
Yes.
Yes, sir.
Yes, I'm sorry.
Okay.
Yes.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B. Probation sentencing will be
October 2nd at 10 a.m.
October 2nd, 2025, 10 a.m. before Judge Washington. Bond will continue.
Your Honor.
Thank you.
Your Honor, is the court in receipt of her progress violation report for pretrial services?
I see it, and in looking at it, I think it's something that Judge Washington will address.
Thank you.
Court does call the case of the People versus Virgil Dunlap. 2 cases.
Trevor Mabel for the people.
And Edward Lucas for Virgil Dunlap, who was approaching you.
And are we ready on any of the?
Yeah, they're still. I've got everybody who's in the call stick it up.
Yeah. Go ahead.
State your name.
Vote to Dunlap.
Thank you.
Thank you, Your Honor. Asking for exam in both these matters. I understand that discovery, to my knowledge, is complete.
You say discovery is complete?
Yes, Your Honor.
People have their witnesses available September 9th.
Yes, Your Honor.
Preliminary examination in these matters will be set September 9th, 2025, 9 a.m. before Judge Valvo.
Thank you, Your Honor.
Court does call the case of the People versus Robin Finney.
Good morning, Your Honor. Laura Yaki, Assistant Public Defender, with and on behalf of Ms. Finney, who's approaching. Ms. Finney, can you state your name for the court?
Yes, Robin Lee Finney.
Trevor Mabel for the people, Your Honor.
And Your Honor, I am requesting a brief adjournment in this matter. I did just receive this morning, Ms. Finney's case manager was here in court and just gave me some information as to her plan moving forward this morning. So I need to get that to the prosecutor.
September 11th, 2025, 9 a.m.
Thank you, Your Honor.
Court does call the case of People versus Deontay Clifton.
Edward Lucas for Deontay Clifton.
Deontay Clifton?
Yeah,
You got it? Okay, state your name, sir.
Deontay Clifton.
Thank you.
We're asking for an exam in this case. I believe discovery is complete.
And what facility is he in?
He's over in Jackson.
Jackson. I think I'll probably have to go another week. People have their witnesses available on the 16th. Preliminary examination in person will be set September 16th, 2025, 9 a.m. That's before Judge Washington. Bond will continue.
Thank you, Your Honor.
Case of the People versus Alua Gillis.
If you're getting ready to go on Medicare, here are 5 mistakes that you want to avoid. And trust me, you do not want.
On behalf of the people.
An Assistant Public Defender, Jay Bellinger, on behalf of Ms. Gillis. Ms. Gillis, can you please state your name for the record?
Lua Gillis?
And Your Honor, I have been able to speak with the doctor at the CFP. He just called me yesterday. He informed that in the next couple of days, he's anticipating sending the facts of the report to our office. So I'm anticipating that within the week. However, we have not received that.
And I think that's right. The only thing I saw in our file was a note saying that the report itself was delayed.
Got it. All right. Then I'll adjourn the hearing to September 11th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court does call the case People versus Jay Dingman.
For Douglas, for the people.
The Public Defender Natalie Pate with and on behalf of Mr. Dingman, who I believe is appearing via Zoom from the jail. Sir, can you please ask the CO to unmute you and state your name for the court?
Jay Dingman.
Thank you.
Thank you. I'm respectfully requesting an adjournment. I did go down to meet with Mr. Dingman on Monday at the jail and was informed that he refused the visit. I did then subsequently learn that his mental health treatment court acceptance has been rescinded by that treatment court. That being said, I need to have a discussion with him regarding options moving forward. So I would ask for an adjournment.
Probable cause conference will be adjourned September 11th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor. Thank you, Mr. Dingman.
Court calls case People versus Anton Brooks.
Good morning, Your Honor. Please, this honorable court, Brandon Bird on behalf of Anton Brooks. Mr. Brooks, can you please state your Anton Brooks?
Assistant Public Defender Natalie Pate, also on behalf of Mr. Brooks, in the case ending in 1261.
6-1. All right.
Your Honor, respectfully, we're just asking for a brief adjournment to get the body cam and go over with my client.
You have green sheet.
And Your Honor, I am joining that request. The discovery in my case is complete, and I have reviewed that with Mr. Brooks, but we were just hoping to keep these two cases together.
Gotcha. So you have the discovery?
I don't have the body cam, Your Honor.
All right. Will the body cam be available next week? Probable cause conference will be adjourned September 11th, 2025, 9 a.m. Bond continued. Both matters.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case People versus Krista Riopel.
Master Veldis for the people. And Assistant Public Defender, Nancy Carey, Your Honor, on behalf of Ms. Carissa Riopel. That's who you called, right, Judge?
Yeah.
Yes. But I do have a green sheet for the court. We are asking for an adjournment. This has been quite some time that we've been working on this case, but I think we're at the end. We did have mitigation completed. I have reviewed that with Ms. Riopel and I have forwarded to the people's attention. So they just need time to review for consideration.
All right. Ms. Riopel, can you state your name, please?
Carissa Riopel.
All right. Thank you. Probable cause conference will be adjourned September 11th, 2025. Now,
Thank you, Your Honor. Thank you, Your Honor.
thank you, ma'am. Court does call the case of the People versus Rashad Keys.
The keys, Your Honor.
Yes.
Master Veldis for the people.
Good morning. May it please this honorable court, Kareem Johnson, appearing on behalf of Mr. Keys.
Keys, can you state your name, please?
Shaw Keys.
All right. Okay, what are we doing on this?
Your Honor, we have discovery. We're asking the court to set this matter for preliminary examination.
People have their witnesses available the 9th?
We will try for that. Thank you, Your Honor. I will alert the court there is a co-defendant who is up this afternoon with Mr. Bernstein, Mr. Durhal. It's in the 4 o'clock block. So obviously people would like to keep the cases together if at all possible.
All right. And Mr. Johnson, have you been in contact with the co-defendants counsel on this?
No, Your Honor, I have not.
You have not.
Mr. Bernstein's right here.
Will that work? Okay. All right. Just remind me because I'm not going to remember that by 4 o'clock. All right. Preliminary examination in this matter in person will be set September 9th, 2025, 9 a.m. That's before. Oh, they're both before me. Bond will continue.
Thank you, Your Honor.
All right, thank you. Ready. Court recalls the case of the People versus Marcus Jones.
Master Veldis for the people.
Again, Your Honor, Sam Bernstein with and on behalf of Mr. Jones. Mr. Jones, could you please state your name for the court again?
Marcus Jones.
Your Honor, thank you for the opportunity to pass and speak on it. We have discussed it. I don't know, do we need to do an arraignment right now?
Yes, we do.
Your Honor, we are in receipt of the amended complaint. Ask the court to please waive reading, and Mr. Jones stands mute.
All right. Defendant having waived formal reading of counts 4 through 6. Standing mute, the court will enter a not guilty plea.
And it's still his wish to move forward to examine, Your Honor.
So the charges don't affect your request for discovery, you don't?
Oh, Your Honor, factually, everything remains the same. Thank you, Doc.
Preliminary exam. People have their witnesses available the 9th,
We'll drop that in, thank you.
September 9th, 2025, 9 a.m. That is before Judge Valvo. Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the cases of the people versus Carlos Sal.
However, on behalf of Mr. Self, who is approaching the podium as we speak. Mr. Self, once you get up here, please state your name for the record. Carlos. So, I need your signature there. So, Your Honor, today is the date and time set for preliminary exam. Mr. Self has decided to waive his exam on both matters.
Is that correct, Mr. Sal?
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have that hearing and that you'll proceed to circuit court on the single count in both matters.
Yes, sir.
All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over circuit court on each count in the two cases.
Thank you, Judge. Stand mute at this time. Stand mute. Waive formal reading.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for September 8, 2025, 1:30 before Judge Hammoud.
And if we may be heard as a bond.
Briefly.
Thank you, Judge. So Mr. Self is currently in Dawn Farm in-jail treatment program. We are asking that he be released to treatment when a bed becomes available for inpatient.
Prepare the order. Customarily, I will sign that, so I just need an order.
Thanks, Judge.
In all other respects, bond will continue. Court calls case People versus Tariq Wilson, a recall.
Assistant Public Defender, Tanazi Carey, I can rule, Your Honor. On behalf of Mr. Tariq Wilson, Mr. Wilson, state your name for the record, please.
Tariq Wilson.
Okay, he can hear us.
Judge, we respectfully request that this matter be set for preliminary examination.
Discovery is complete.
To my knowledge, Judge, yes.
And what facility, where is he?
Hidden inside the wires of every home is a flaw, a silent leak that energy companies never bothered to fix.
MTU.
Okay, yeah, I see that on the screen. Where?
Ionia.
Where are you?
Ionia, Judge.
Ionia, Michigan.
Gotcha. People have their witnesses available on the 16th. Preliminary examination in person will be set September 16th, 2025, 9 a.m. That is before Judge Perry.
Thank you, Judge.
On continued. Thank you.
In person?
In person. Thank you, Mr. Wilson. Court does call the cases of the People versus Moses Steiger.
Trevor Mabel for the people, Your Honor.
And good morning again, Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Seeger in one of his matters.
Ralph Cole, Judge, I'm on case 25 F2 1351 and 1193. I was just appointed. I've spoken with Moses, explaining that we need more time. We're asking for an adjournment on this matter.
Ms. Yagi, you're going along with that.
That's correct, Your Honor.
All right. Probable cause conference, September 11th, 2025, 9 a.m. Bond continued. Thank you.
Thank you.
Proposed case of the People versus Mark Jackson.
Assistant Public Defender Alexis Dirks with and on behalf of Mr. Jackson, who I believe is in custody, Your Honor.
Hello.
Yes, state your name.
Mark Jackson.
Your Honor, we'd respectfully request an adjournment if we can be heard on bond.
Probable cause conference will be adjourned September 11th, 2025, 9 a.m. As to bond, briefly.
As to bond, Your Honor, we'd be asking for a release with a GPS tether. Mr. Jackson was incarcerated in Georgia at the time that he missed his earlier probable cause conference, and then he spent the additional time in Georgia to
What was
get
he incarcerated in Georgia for?
a case down in Georgia, Your Honor.
Really?
To my understanding, I was able to get the records from Muskogee County Jail that said he was incarcerated. He was incarcerated for about 2 months, and then he had a case.
Or?
I believe Mr. Jackson explained to me it was a marijuana case. Your Honor, he has all of the proof of the rest of his case and the probation sentence that he had to serve while down in Georgia in his vehicle that was impounded as a result of him being brought into the Washtenaw County Jail. We could provide additional documentation if he was allowed to be released on a GPS tether. I do currently have the proof of his incarceration at this point, but that is all I have.
Response.
Your Honor, I believe the defendant's bond is appropriately set. I previously failed to with probable cause conference 2 years ago, and I do not believe he voluntarily turned himself in.
Your Honor, it's my understanding that he was picked up on a traffic stop on his way home from work. So he had just recently came back to Michigan, got a place to live, got a job, and was providing support for his children. He got pulled over.
And just not taking care of this.
Yes, Your Honor, because my understanding was he was still in the state of Georgia up until that point.
Motion for bond reduction is denied. Bond will continue.
Thank you, Your Honor.
Court does call the case People versus Sherry Walker.
Good morning again, Your Honor. Brandon Bird on behalf of Sherry Walker. Ms. Walker, can you please state your full name for the record?
Sherry Walker. How you doing?
Yes, Your Honor. My client has another matter coming up on the 4th. She's supposed to be finishing Don Farms on the 4th. I'm just asking for adjournment because I believe that we make it.
She has another felony coming up, or another. Go ahead. What?
But I don't think it's a felony drop. It's misdemeanor. But they canceled Don Farm this morning.
So she doesn't have another felony case coming before me.
That's what I was aware of yesterday. It's not a felony.
I have one in Wayne. But
respectfully,
no.
Respectfully, Your Honor, if we could just get an adjournment to come up with.
Well, yeah, right. But I put her to the 11th. But if she's got a matter, she doesn't have a matter here on the 4th.
That's what she indicated to me yesterday. Do you have a matter on the 4th?
Yes, come here.
And it's in front of judge?
Yes.
Is it for a felony?
No.
I'm not sure. Well, that's all I plan on doing that day. So if you've got a case before me, it's going to be a felony matter. And can you?
I have knee pains. I wake up in the morning, I'm in pain. My shoulders kills me. With Omega XL, I'm actually stunned as to.
Okay, you're trying to do 8 things.
And I apologize, Your Honor. I did visit my.
No, it's all right. Well, we don't know. She's saying it's for me on the 4th, which would make it a felony matter, but I don't.
Your Honor, we're not aware of another felony matter.
Do you see anything else that she's got pending before me? Not on the 4th. Nothing. You're requesting an adjournment?
Yep, I'm requesting an adjournment, please, Your Honor.
Probable cause conference will be adjourned to September 11th, 2025, 9 a.m. Bond continued.
Just permission to address bond real quick.
Go ahead.
They did cancel Don Farms today on my client. I didn't get the reason. I do understand my client wants to get this handled. I believe we can come up with a resolution in this matter. Respectfully, we're just requesting a personal bond in this matter.
All right, response from the people.
Honor, if she has a newer case, we do have some concerns about a changing bond at this time with effort.
Well, I don't know if she has a newer case. Were you able to find anything on her?
She's got something in front of Judge Barr.
She's got another matter, I'm informed, in front of Judge Barr.
That's a 7 conference.
They keep them on days on it.
She's got a current matter that's pending before Judge Barr.
Thank you. Thank you. Okay, if we could just get an adjournment in this matter.
I already adjourned it. I was trying to figure out the bond, but.
Never mind. No bond.
Okay.
On the bond, sentence.
And I guess that you made the formal motion. Okay, on this matter, the record should reflect we've had a bench conference in this case. My understanding is we're setting this for jury final settlement conference and jury selection. Set that for October 17th, is it? October 17th, jury final settlement conference, October 17th.
Style starts with the details. The difference between mid and next level, a real gold.
2025 at 9 a.m. Jury selection would be October 20th, 2025 at 8:30. There has been a mention regarding the defendant being in Wisconsin. I will set these both as in person, but I understand we potentially made alternative arrangements. Like, all right.
Thank you, Your Honor. We'll make a request on the.
All right.
Weird one. Thank you.
Thank you. Bond will continue. Court does call the case of the People versus Jillian Sartori.
Josh Phelps for the people.
And Your Honor, just on behalf of Sartori. State your name, Jillian.
Jillian Sartori.
All right.
And we have the resolution. Thank you.
I have before me a plea form that indicates that the defendant will be pleading guilty to the charge of retail fraud in the third degree, the 93-day offense. There is also a sentencing agreement between the prosecutor and defendant of HIDA and restitution of $152.16.
That's correct, Your Honor. And did the court get the agreement to hide? I'm sorry, I missed it.
Yes, I said HIDA and restitution.
Thank you, Your Honor.
Right. Thank you. That's true, Your Honor. And the agreement is, it's extended HIDA, so it's necessary for.
The prosecutor.
Yes, thank you.
All right, very good. May I have her?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So state your name.
Jillian Sartori.
You can. All right. I'll just need you to speak up a little bit if you would, okay? Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of retail fraud in the third degree. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased at 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes.
All right.
Your Honor.
In understanding all of that, you will.
Yes, Your Honor.
And also because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
On the date. Do you see the complaint in this one? I don't. No.
I think that's the second page right there.
Open the phone. I was complaining.
Does Court need a copy?
You're right. Thank you. First, I get it. On the date of October 18, 2024, at the location of 3749 Carpenter Road in Pittsfield Township, Washington County, State of Michigan, what did you do at the Target store that makes you think that you're guilty?
Could you repeat the last sentence?
What did you do at the Target store that makes you think that you're guilty?
I stole from Target.
Okay, you went into the store
Yes.
and you took some items?
Yes, Your Honor.
All right. Tried to walk out of the store without paying for them?
Yes, Your Honor.
The store was open to the public at the time?
Yes, Your Honor.
You didn't have anybody's permission to take that property, did you?
No, Your Honor.
And the property you took was property that was offered for sale by Target?
Yes, Your Honor.
All right. Ma'am, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, you commit misconduct as defined under the Michigan court rules, the court would no longer be bound by any sentence evaluation or agreement. You understand that?
Yes, Your Honor.
You also would not be entitled to withdraw your plea. You understand that?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor, the people are aware of an additional case that would technically be a bond violation for this case. We're not intending on pursuing it as a bond violation case. Want to make sure the record's clear on that.
All right. And
Thank you, Your
the
Honor.
court had been apprised. of
Yes.
that.
Thank you.
All right. Any other things?
No, Your Honor, thank you.
And has the court complied with the court ruling? Would it be proper to accept this defendant?
People are satisfied?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be September 24th, 2025. Are we doing that?
Pardon, Your Honor?
Yes.
9 a.m. Bond with its conditions will continue.
Thank you, Your Honor.
Thank you, Your Honor. Conference room.
Court does call the case of the people versus Aline Wood.
Ashley Bellis for the people.
EVE Online is a
Morning, Tom Pietrowski on behalf of Ms. Wood, who's in court today. Standing to my right, ma'am, would you introduce yourself, please?
Hello, my name is Aileen Jane Wood.
Thank you. All right, what are we doing?
Yeah, I believe we're at a point where we're just asking the court to set a final settlement conference, and I think those dates are sometime in October.
Jury final settlement conference will be set October 17th, 2025, 9 a.m. Jury selection, if necessary, October 20th, 2025, 8:30. Both of those proceedings are in person.
Yeah,
Thank you.
may I ask the court a question?
Yeah, I don't know if I'll, go ahead.
For scheduling purposes, we would be intending, and I let Ms. Lonnie, I'm sorry, let the prosecutor know that I haven't changed my name, believe it or not. That our intention would be to waive. I don't know if the court needs to know that now or.
You want to proceed to this and then make a determination that you may waive.
That's correct.
All right,
We
yeah.
would bench after counsel.
Right.
All right, very good.
Sounds good. Thank you, sir.
Thank you. Bond will continue. Court does call the case of the people versus Joseph German.
Your Honor.
Ashley Bellis for the people.
Good morning, Your Honor. May it please this honorable court. My name is Jay Dallow, P number 72879. Appearing on behalf and with my client, Mr. Joseph German, who stands to my right. Sir, can you please state your name for the record?
Joseph German.
Your Honor, today's date and time set for a pretrial on this matter. I've had the opportunity and the pleasure to speak with Sister Counsel.
That's funny. Pleasure. Go ahead.
But it's true.
Yeah, okay, whatever. You're still young. Go ahead.
Thank you, Your Honor. We're going to be submitting, we've submitted a deviation request. We've updated and had it forwarded to Sister Counsel. I think both parties are just asking for 2 weeks if we can return, if Zoom, if it would please the court to appear via Zoom. As much as I love Ann Arbor and I went to school here, I did
Sorry
drive.
to hear that.
Okay. You're not a Buckeye, are you? Okay.
Alan, take it.
Well, you are wearing red.
Am I a Buckeye?
I did
to Michigan. I grew up here, but he went to Michigan and he asked me if I'm a Buckeye.
Yeah, well, based on
You
your,
want to know?
I did drive about. I live in Sterling.
He's just not acquitting himself well. So any request you make, no.
Good. So any request?
I am a very proud Maryland terrapin.
Oh, that's cool.
I know.
So any request I say, ask would be no. So we would like to appear in person. So
no.
Yeah.
Okay. Very good.
You're right. Yeah. Thank you, Judge.
What's my next date? 17. Does that work for you?
That's perfect, Your Honor. Thank you.
I'll adjourn the matter to September 17th, 2025, 9 a.m. Bond will continue. and you'll have to submit the full. During the matter of September 17th, 2025, 9 a.m. Bond will continue. Thank you. Court does call the case of the people versus Jason Eckley.
Good morning, Your Honor.
Good morning. Go ahead, counsel. Place your appearance on the record.
Thank you. Good morning again, Your Honor. Robert Goldman, P81222, appearing on behalf of defendant Jason Eckel, present by way of Zoom this morning. We thank the court for its accommodations to appear by way of Zoom. Mr. Eckel, could you please state your full name for the record?
Jason Eckel. And what are we doing today?
Thank you, Your Honor. This is a date and time set for a first pretrial in this matter. I did receive discovery from the prosecutor's office. I do need to follow up regarding one piece of discovery that I'd like to further inquire into. However, in the interest of judicial efficiency and economy, I would ask if the court could schedule the matter for a final settlement conference, during which, in the interim period, I can address the request or inquiry with the prosecutor's office. And otherwise prepare to try to resolve, but if not, we'll be prepared to proceed with trial in the matter.
Your Honor, if the court wouldn't mind, could we just adjourn the discovery over? I want to make sure defense counsel has everything he needs. We don't have to delay this case at final settlement if there should be something missed.
If you're looking for additional information and discussion, I'll just adjourn the pretrial out. I'll adjourn the pretrial to September 17th, 2025, 9 a.m.
And Your Honor, I'm getting into the Zoom in just a moment. I'll put my contact information in the chat so defense counsel can email me directly.
All right. Very good.
Thank you.
Wait a second, I'll be right there.
All right. Thank you. Bond will continue with its condition. Thank you.
Thank you, Your Honor.
Court does call the case of the people versus William Dapkowski.
People.
Good morning, Your Honor. Paul Pafelski for Mr. Dapkowski, who is in person.
Yes. Your name, sir?
William Dapkowski.
All right. Very good. What are we doing?
Your Honor, Mr. Dapkowski, the last pretrial was adjourned for Mr. Dapkowski to be screened for participation in the sobriety court program, and I did receive an email from Mr. Heaton that he had been approved and accepted for participation in the program. So we would be prepared today to tender a plea to the charge of OWI second. And Mr. Heaton asked for a sentencing date of 9/25 at 9:30 a.m. for him to be accepted into the program, if the court will go along with that.
Well, I have to, how are we doing that? Are they sentencing the entire sentence or?
Simple. I only pay $10 a month for my internet connection. Fast, unlimited, anywhere. Have you heard about Rio?
The transfer of that into 14A. Do we have clarification on that?
We do not have clarification. I do know that we received an email from Mr. Heaton that indicated that they could see him the day after our next sentencing docket.
So I would set we're just going to do it that way.
Yeah.
All right. So what will happen, counsel, is I'll be here. He's got the 25th date, but I will be setting my sentencing date because it's a little bit weird, but I will be assessing at that time fines and costs and then referring him to the court. Seems an odd way to do it since we're all one court, but we haven't worked out all of the details. All right.
Thank you, Judge. That's fine.
All right. Very good. Sir, if you can please raise your right hand to be sworn.
You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth self.
Yes.
State your name.
William Dapkowski.
And he's going to plead to operating while intoxicated second offense. Is that correct?
Yes.
All right. Sir, it is this court's understanding that you're going to plead guilty to the charge of operating while intoxicated second offense. That is a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs. The court could order community service and any rehabilitative services the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
Yes, Your Honor.
In understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
I do also have to advise you that, well, actually, you'll be sentenced by me, but you'll also be appearing before Judge Freshour. You understand that, sir?
Yes, Your Honor.
All right. Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind?
Yes, Your Honor.
All right. Did you sign an advice of rights form, sir?
Not at this time, but I can do that.
He may have done one. He may have done one previously, Your Honor. I'm not sure, but I did review the form with him.
So do you recall reviewing an advice of rights form with your attorney?
Yes, Your Honor.
All right. Do you have any questions? I've handed you a copy. Do you have any questions regarding any of those rights?
Not at this time.
All right. Please look at paragraph 5. You'll see a copy on the podium highlighting paragraph 5. Those are your rights which are part of the trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been, has anybody promised you anything to get you to plead to this charge?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor.
Of your own free will?
Yes, Your Honor.
And because you believe that you are indeed guilty of this offense?
That is correct, Your Honor.
March 12, 2025, at the location of Laura Road near Textile Road in Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes, I did.
What did you have and how much?
At least a pint and many beers. So I was
pint of
vodka.
Okay. Were you stopped by the police or was there an accident?
I was stopped by the police for speeding.
For speeding?
Yes.
All right. You're not disputing the right of the police to stop you, are you?
No, Your Honor.
All right. Were you ultimately arrested?
Yes, Your Honor.
Were you taken to the hospital or to the station?
I was taken to the police station.
All right.
And Your Honor, I have the results of the.
Was that an intoxicator?
It was intoxilizer, yes, Your Honor.
Okay. And were the results of that 0.137, sir?
Yes, Your Honor.
All right. Do you have any reason to dispute those results?
No, Your Honor.
Prior to that, on July 14, 2022, City of Adrian, were you convicted of operating while visibly impaired?
Yes, Your Honor.
All right. Sir, I do have to advise you that if you commit misconduct as defined in the Michigan court rule between the time of my acceptance of your plea and the time of sentencing, that any agreement or evaluation, the court would no longer be bound by. You understand that?
Yes, Your Honor.
All right. Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
Your Honor, only the entry into sobriety court that we've already.
The entry into, right.
Nothing else.
Nothing else, counsel?
No, Your Honor.
All right. And have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
Defense is satisfied.
All right. Court will accept the defendant's plea of guilty to this charge. Has he already been assessed at, he's done an assessment already, is that correct?
Yes, he has with probation, and Mr. Heaton has sent an email accepting him into the program.
Okay, so here's what I'm going to do. I'll refer you, I'm not going to refer you to Von Swartz, but I'll refer you for an assessment, which you've already ideally completed. I'll set sentencing for this part of the case for September 24th, 2000. Is that right?
Yes.
September 24th, 2025, 9 a.m., or as your invite indicates. And then you'll have the next appearance on the 25th.
Okay.
Okay. We'll do it that way. Bond with its conditions will continue. Thank you.
Thank you.
Court does call the case, People versus Damian Poupette.
House votes for the people.
Good morning, Your Honor. Excuse me. May it please the court, Ezra Golden on behalf of Mr. Poupette.
My understanding is he's going to enter a plea to the charge of operating with a high BAC and to proceed to immediate sentencing with the 15th District Court sobriety.
There should be a plea form, Your Honor, for operating while visibly impaired. Second offense.
That's what I was going to say.
Most people don't realize that one simple nightly habit can have such a big impact on how you feel. It's not a diet.
You do.
So that is what we'd like to do today, Your Honor. Please go down and count 2 of operating while visibly impaired, second offense, 2 going to sobriety court, count 1. I do believe that he has been screened and assessed and accepted already. to 15, if I recall correctly. Based on what he does.
Sentence agreement that he's to enter that sobriety court
Yes,
has
Your
been
Honor.
accepted into that program.
Yes, sir.
That's the court's full understanding of the agreement.
Mine as well, Your Honor.
I will check the sentencing. He understands that I'm going to pose the first part of a sentence. Counsel.
Part here and part there. You know, Your Honor, every district judge does this a little differently, but yes, I understand.
I do it right, though.
Okay,
but
yes.
All right. That I will be doing that. So what I've done is he understands the sentencing judge waiver in this case.
Exactly.
Because he'll have the other part. We'll just cover that. All right. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Damian Pupa.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of operating while visibly impaired second offense. Is that correct? All right. That is a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental service. You understand that?
Yes, Your Honor.
Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind?
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
Not at this time.
Look at paragraph 5, you'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that.
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yes, Your Honor.
Are you on probation or parole?
No, no.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor.
Of your own free will?
Yes, Your Honor.
And because you believe that you're indeed guilty of this offense?
Yes, Your Honor.
February 22nd, 2025, at the location of I-94 near Ellsworth at Pittsfield Township, Washington County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
Yes, Your Honor.
What'd you have and how much?
Some whiskey, 3 to 4 glasses.
All right. Were you stopped by the police or was there an accident?
I was stopped by the police.
Why'd they stop you?
They said I was driving under the speed limit.
Okay, so you're driving too slow for the highway?
Yes.
All right. Are you disputing the right of the police to stop you in this case?
No, Your Honor.
All right. Were you ultimately arrested?
Yes, I was.
And were you taken to the police station or hospital?
I was taken to a hospital.
All right. Was there a blood draw?
Yes.
Were the results of that blood draw 0.192?
Yes, Your Honor.
Do you have any reason to dispute those results?
No, Your Honor.
Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes, Your Honor.
All right. Had you previously been convicted of operating while impaired on or about September 24th, 2024 in the 35th District Court?
Yes, Your Honor.
All right. Sir, if I do accept your plea in this case, and you commit misconduct as defined by the Michigan court rules between the time of my acceptance of your plea and the time of sentencing, any sentence agreement, the court would no longer be bound by, and you could not withdraw your plea. You understand that, sir?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Just a sobriety court, Your Honor, nothing else. Thank you.
Nothing else, Your Honor.
All right. Have I complied with the court rule, and would it be proper to accept this defendant's plea?
People are satisfied.
That's fine, Your Honor.
Court will accept the defendant's plea of guilty to count 2, the operating while visibly impaired second offense.
It is his second offense. He's looking forward to the opportunities offered by the sobriety court and has a positive attitude about that. So I don't think the court will see him back for any violations.
All right. Anything you want to say, sir?
Not so right now. I just want to say I don't want to be here, and I'll do everything I can to not come back.
You know, sometimes I feel that way. All right. It's the sentence of the court. Place you on 24 months probation, term with supervision through the 15th District Court, Sobriety Court. You're to pay $1,255 fines and court costs. That's payable to 14A1. $100 prosecution recovery costs. That's also payable to this court. And $100 police agency recovery costs payable to this court. When can you pay that, sir?
melt sales objections with this book. I just got my black book of questions in the mail.
If you need 60 days, then whatever, 60 days. 60 days.
Do you have anything today that you can pay on this?
Set a date. Today. Today.
Can you pay any of it today is the question.
Yes, I can pay some today.
Okay, how much can you pay today?
I can pay $500 today.
Thank you. $500 today, and then I'll indicate that the balance would be due by November 1st, 2025. Probation oversight fees will be set and paid to the 15th District Court. You're to comply with all terms and conditions of the 15th District Court Sobriety Court. I'll order 365 days of jail. Credit 1, the balance is suspended.
All right. One question, Your Honor. He has a tether. So he has a tether from his bond. I'm wondering if that's something
that will continue until such time as the 15th District Court makes it.
Or does it remove?
And that will be the request of the people as well, Your Honor, that it continue.
All right.
Okay.
Okay. Thank you. Court calls the case of the people versus Jennifer Carlara.
That's called the people.
Good morning, Your Honor. Marissa Boyles, P86438, on behalf of Ms. Galara.
Good morning.
Good morning. You're
Jennifer Galara.
Thank you. All right. What are we doing on this case?
Your Honor, we would be sorry, go ahead.
Go ahead.
We'd be requesting an adjournment on this. We have received discovery. She does have a substance abuse evaluation scheduled, I believe, within the next couple weeks here, as well as a hardship case scheduled for October 1st. We would be requesting an adjournment.
Bond violation?
I have. And counsel, are you aware of the bond violation?
I am aware of it.
All right. Would you like to address that?
I do believe she has a court date scheduled on it within the next couple weeks as well. It is for driving without a license. There are some underlying issues regarding the status of her license. So if we could adjourn the bond violation to the next pretrial, I think that would be best.
Anything from the people on the bond violation?
It's concerning, of course, to the people that she was driving. But most concerning to me was the fireball in the back.
Yes.
So those are sort of the things that I would put forward to the court. I don't know if there would be a resolution necessarily like that. Where do we go from here, right? Like she's driving, she didn't have her 625G and she had fireball. That's very concerning when someone's on bond for an OWI. I think, let me double check these notes. She had gotten a silver link because she was found to be in possession of alcohol. And I understand that she was saying she didn't know it was in the car. I am going to request that the court consider putting her on a scram tether. This is sort of a red flag to me.
Well, there are a couple of things. I guess I'm a bit concerned about why did she have her 625G permit or no?
She did initially, and then she only later received notice of the implied consent refusal, which she also didn't refuse. She just had trouble blowing. So she did have the permit and then only received that later. So, I mean, there were kind of some issues as to why there was the implied consent violation, and we are fighting that in circuit court right now.
Yeah, but she did know at the time that she didn't have a 625G permit. Did she not? Counsel?
That I don't know.
Part of the problem that I have here, counsel, is that she's driving. She's not supposed to be driving. And then there is Fireball whiskey in the back of her vehicle. And she's not to be in possession or consumption of any alcohol.
I I do understand that, Your Honor, and to my knowledge, she has been sober since the offense, doing everything she can. So I don't believe she had any knowledge of that fireball being present. As
What's
we
the
have gone over her
monetary
bond conditions with her, and she is very aware.
25. Okay, well, counsel, if you want to get down here so we can address this later, but at this time, I'm going to take her into custody. Your bond on the warrant that I issued is set at $25,000 cash surety. So she can post, or you can come down and I can have her brought back out. But at this time, I'm going to take her in.
Can she post a cash bond today?
Pardon?
Can she post a cash bond?
It's, if she has it, she can post a cash bond.
Okay.
I mean, I'll allow a 10% on it, so that she doesn't have to go through a surety if that would assist on that. But it's that mean it'd be $25,000. I'll give a 10% privilege on that.
Okay.
All right. What were we going to do with the case itself?
The case itself, like I said, we received discovery. I think we have some ongoing negotiations regarding an offer, and she does have a substance abuse evaluation scheduled, I believe, September 10th.
All right. So what I will do is I'll adjourn her case to September 17th, 2025, 9 a.m. At this time, the defendant is remanded. Her bond will be set at $25,000, 10%.
Will the court also order the scram?
Not at this time.
Okay, thank you.
If you're an entrepreneur and you're making less than $50,000 a month, I want to tell
Thank you. Court does call the case of the people versus Justin Kitari.
People.
Good morning, Your Honor. Oscar Rodriguez, on behalf of Mr. Katarai, who is present, and speak your name, please.
Justin Katari.
All right. What are we doing?
Your Honor, I have not been able to with the prosecutor, but I do have a request to change the bond conditions that we'd like to make.
Okay. Well, first of all, what are we doing on the case itself?
Your Honor, I haven't heard any offers. Again, prosecutor and I have not been able to chat, but that's where we stand there. Obviously, if we have no resolution, this case needs to move forward towards trial. But I'm not sure if there are going to be any offers.
Did you want an adjournment of the pretrial? Or you want me to set it on the final settlement conference?
I think we can get an offer here, Your Honor.
All right. I'll adjourn this out so you guys can talk. I'll adjourn this to September 17th, 2025, 9 a.m. Yes, as to bond.
Your Honor, we have been on the scram tether for now about a month and a half, and our request is to, in terms of saving money, to be put on the breathalyzer instead. The testing will still continue all the time. He has had no violations. He has his 30-day chip from AA, and so that's essentially the request. If we can go to the daily monitoring breathalyzer instead.
I'm going to deny that request. I don't need a response from the people. The basis for which he's on the scram tether is that his alleged blood alcohol was a 0.234. He has a prior driving while alcohol related offense, and there was a crash in this case. So I'm not changing that bond condition.
Thank you, Your Honor.
So request to change that bond condition is denied.
Thank you.
We'll see you in a couple of weeks then. Thank you.
Thank you.
Court does call the case of the People versus Eric Hopkins.
Josh Feltus for the people.
An arraignment. Just an arraignment.
Good morning, Your Honor. Wonderful to see you. Robert Ellman with and on behalf of Mr. Hopkins. Mr. Hopkins, can you state your name for the record?
Eric Hopkins.
Thank you.
I don't have anything marked in this one. It is an arraignment. All right. As to the arraignment portion.
Your Honor, we would stand mute and waive formal reading.
Defendant in every way, formal reading, standing mute. Court will enter a not guilty plea to this charge. All right. And what are we going to do in this case?
Your Honor, I've been having wonderful, fruitful conversations with Mrs. Feltus, and I'm hoping that we will soon be able to reach a resolution, but we need a little more time to figure that out. And so I would ask for an adjournment to your next pretrial date.
We'll adjourn the pretrial in this matter to September 17, 2025, 9 a.m. or as your invite indicate, I'll set the defendant's bond in this case as a $5,000 personal recognizance bond. I'll order standard conditions, including no assault behavior or possession of any weapons. There is to be no alcohol, no use or possession of any alcohol, recreational marijuana, or any illegal drugs. You understand that, sir?
Yes, Your Honor.
I'm also going to order that you are not to enter any Home Depot in the state of Michigan. You understand that?
Yes, Your Honor.
All right. Anything further?
No, Your Honor.
Thank you. Court calls the cases of the People versus Rick Artuso.
Josh Feltus for the people.
Assistant Public
Defender. Not all.
Assistant Public Defender Natalie Pate with and on behalf of Rick Artuso in the cases ending 1656 and 1657.
And good morning, Your Honor. May it please the Honorable Court, David Burgess on behalf of Rick Artuso is the remaining man.
Your name, sir?
Rick Artuso.
Okay, what are we doing?
Your Honor, there's a resolution as to my two cases. There should be a plea form in the file as well as a signed advice of rights form.
I see. Okay, I get it. Okay. And then what about your case?
Your Honor, Ms. Feltus has got that right today. I'm working on it here.
Yeah,
I'm a little
me
slow
too.
here. I'm a little slow sometimes, Your Honor. But she extended an offer to me. I do need to discuss with Mr. Artuso. So on my matter, I'm going to ask for an adjournment, Your Honor.
That's on 217.
Correct.
I'll adjourn that matter to September 17, 2025, 9 a.m. as bond in that case will continue.
Thank you very much, Your Honor.
All right. Thanks. And on the other matters, Mr. Artuso?
Yes.
Can you raise your right hand, sir? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes.
All right. State your name again for the record.
Rick Artuso.
All right. It's this court's understanding, sir, that you are going to be pleading guilty to the charge of no insurance.
Yes.
Is that correct?
Yes.
That is a misdemeanor punishable by a fine between not less than $200, not more than $500 plus cost. Do you understand that, sir?
Yes.
I don't think, and I think it's up to 1 year. Is that the one?
Correct, Your Honor.
And up to 1 year incarceration. You understand that, sir?
Yes.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind?
Yes.
You signed an advice of rights form, is that correct, sir?
Yes.
Any questions regarding any of those rights?
No.
Looking at paragraph 5, those are your rights which are part of a trial. Do you understand that you'll be giving up those rights as well follows all the rights on that form.
Yes.
You understand you're giving up your right to appeal upright.
Yes.
Are you on probation or parole?
Not at the moment.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense, sir?
Style starts with the details. The difference between mid and next level, a real gold chain.
Yes.
On the date of December 19, 2024, at the location of Hillside Road near Ellsworth, in Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes.
And at the time you were operating that motor vehicle, did you not have insurance or security regarding that vehicle?
No, I did not.
Okay, and you knew that to be the case, sir?
Yeah.
Okay. Sir, if I accept your plea in this matter, between the time of sentencing, the acceptance of the plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, you could not withdraw your plea, and any evaluation by the court or recommendation by the court would no longer be bound by. You understand that, sir?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor, I don't know if it was just stated on the record, but just what was stated in the plea form, that case then 1656 would be dismissed.
Maybe.
But other than that, no, Your Honor.
All right. And have I complied with the court rule? Would it be proper to accept this defendant's plea?
We're satisfied.
Yes, Your Honor.
All right. Court will accept in case ending in 1657. Court will accept the defendant's plea of guilty to this charge, and the other matter is dismissed. All right. And does he currently have insurance?
No, I don't have that. I don't have that vehicle no more.
I also understand the defendant has at least one pending matter, maybe more than one pending matter in circuit court. So there's sort of other things happening.
So he's going to be under the jurisdiction of another court.
That is correct, Your Honor.
All right. Any objection to the court proceeding with immediate sentence?
No, Your Honor.
No, Your Honor.
All right. Sir, is there anything you want to tell me before I impose sentence?
No.
All right. Fines and costs of $300. When can you pay that?
I need at least a month.
All right. What I'll do is I'll make it payable by October 31st. Will that work for you?
Yeah.
Okay. Pay it by October 31st, 2025, and I will suspend 365 days in jail.
Okay.
All right. Thank you.
Thank you, Your Honor. Mr. Artuso.
If I didn't say so, the other matter is dismissed.
Thanks. Thank you.
Court does call the case, People versus Robert Stevens.
I should felt this for the
Yes, hi, Your Honor.
Oh.
Hi.
And I think Ms. Weidling was just pointing out this was Mr. Gaddy's case as a private attorney. Mr. Gaddy now, I know the court knows for the record, is employed by the Public Defender's Office. So this person may need a new assigned attorney. Because this is from 2016.
I thought that we had wrapped this all up the last time I saw you. I didn't, I wasn't aware that there was another meeting.
What do you mean?
I saw you at the end of, what was it? Probably July. And we had, I had pled to the other cases that we had, and kind of
well,
just
let's
wrapped
do this.
them.
Who was representing you when you appeared before me?
I didn't have an attorney there. It was probation who appeared.
Not appear at the last hearing on this one.
Okay. I adjourn this to today's date. Do you want to be represented by an attorney on this, sir?
No, I think that this is such an old case, and last time we talked, I had explained how I live in Massachusetts now.
No, I recall all of that, but to try to get this resolved, do you want to be represented by an attorney? Because Mr. Gaddy is actually listed as the attorney on this case.
Oh, do I need one, or are we? I'm okay with just pleading, and or is that not an option this time?
It is an option. I'm not sure that it would be the most prudent or wise move, but I can advise you. So this being a public defender case, I'm going to adjourn this out to September 17th, 2025, 2 weeks from today. This is a 2016 case, Ms. Spade.
Thank you, Your Honor.
So I'll adjourn it to that date, 9 a.m. Let's see if we can get this resolved.
And Your Honor, if I may speak directly to Robert Stevens, if you could call the public defender's office and give the best phone number for you.
Okay. Yep. Right. And who should I ask for again? I'm sorry.
You can just say, I need to give my phone number to Natalie, but the number to call would be 734 222 6970.
Okay, thank you. I apologize.
All right.
You tell them you were just in front of Judge Simpson and need to give Natalie your phone number. They'll put you in the right spot.
Okay, thank you.
Thank you. Thank you, Your Honor.
Thank you. Court does call the case. People versus Jeffrey Ostermiller.
National Public Service People. Good morning. Assistant Public Defender Lauren Perry on behalf of Mr. Ostermiller. Mr. Ostermiller, excuse me. Please state your name for the record.
Jeffrey Ostermiller.
Thank you.
Your Honor, I did not have contact with Mr. Ostermiller prior to today. I'm asking for an adjournment of the pretrial hearing, please.
I will adjourn this to September 17th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you. Court does call the case of the People versus Christopher Banks.
People.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Banks, who is present via Zoom. I believe he's trying to unmute him, Your Honor, in front of the Spartan flag.
He's in front of the Spartan flag. I don't want to hear from him anyway. See, this is what I'm talking about. How long does it take us to unmute? Oh, no. State your name, sir.
Christopher Banks.
All right.
Thank you, Your Honor. I have discussed this matter with my client, and then I have talked to the people. There is some media reference in the police report that our office does not yet have. So I'm requesting what I believe would probably be one last adjournment to get that media or confirmation that maybe it doesn't exist before setting it.
All right. I'll adjourn this matter September 17th, 2025, 9 a.m. And I suppose he'll be at a different location with a different flag in the background.
Yes, sir.
I'm just saying. No, you do it. You do you. All right.
Get a Buckeye.
Yeah, do that one.
Thank you, Mr. Banks.
Thank you, sir. Court does call the case. People versus Grace Bonilla.
National Public Service People.
How do I finish, please?
These are all show cause.
No. She has all the remaining ones. Only zeros. 1005.
That's the only one that's on. Bonilla. Oh, I gotcha. No response. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $5,000. I'll give it 10% privilege on that.
Thank you, Your Honor.
That warrant will issue immediately. She had the other. Court does call the case. People versus Daniel Bowe.
Ashley Feltus for the People. Good morning. Assistant Public Defender Lauren Perry on behalf of Mr. Bowe. Mr. Bowe, please state your name for the record.
Daniel Robert Bowe.
What are we doing?
Your Honor, you should have a plea form in your file.
I do. Plea form indicates that he's going to plead no contest, yes, to the charge of retail fraud, third degree, the 93-day offense. Upon a successful plea to that charge, count one would be dismissed. That's the court's full understanding of the agreement.
Yes, Your Honor. Yes, Your Honor.
All right. Sir, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
State your name again for the record, please.
Daniel Robert Bowe.
All right, sir, it is this court's understanding that you're going to plead no contest to the charge of retail fraud in the third degree. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would be the amount of the fine. You understand that?
Correct.
Or the
John.
amount of the maximum fine. All right.
Correct.
Do you understand what a no contest plea is?
Yes.
All right. 2 things about it I have to make sure that you understand. First of all, it means that you're not further desirous or wanting to contest this charge. You understand that?
Correct, Your Honor.
Second thing you need to understand is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Correct.
Basis for the no contest plea?
Potential civil liability, Your Honor.
Oh. Sir, to that charge, how do you plead?
Guilty.
Really?
No contest. I'm sorry.
Thank you. You understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
All right. You signed an advice of rights form, is that correct?
Correct.
Any questions regarding any of those rights?
No, sir.
You understand that you're giving up the rights contained in paragraph 5 as well as all the rights contained on that form?
Correct, Your Honor.
You understand you're giving up your right to appeal of right?
Correct.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Correct.
and of your own free will?
Yes, sir.
Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 2411486. Any objection to the court having reviewed that report?
No, Your Honor. No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could accept the defendant's, could determine the defendant's guilt of this offense. Sir, I do have to advise you, between the time of the acceptance of your plea and the time of your sentencing, you commit misconduct as defined by the Michigan court rules. Any sentence evaluation recommendation the court would no longer be bound by, and you would not be able to withdraw your plea. You understand that, sir?
Correct, Your Honor.
All right. Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor. No, Your Honor.
All right. And have I complied with the court rule?
People are satisfied. Satisfied, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed.
If you have a 700 plus credit score, you qualify for Chase's new program where you can access up to
Defendants referred to probation for pre-sentence investigation and report. Do I have intake here?
You do.
All right. Sentencing in this matter will be
September 24th.
September 24th, 2025, 9 a.m. All right, bond will continue. Sir, I'll need you to wait online. We're going to put you into a breakout room with our probation department so we can get that process started. Okay, sir?
Okay, thank you, Your Honor.
All right, thank you. Court does call the case of the people versus Wesley Brand.
That's felt for people.
Yeah. Your name?
Wesley Bryan.
All right. This is an arraignment. Sir, you are before the court on a complaint that alleges that on or about June 2nd, 2025, at the location of 2201 Hogback Road, Epping, Washington County Jail, that you did commit the offense of assault and/or assault and battery upon an Alton Ford. You understand the nature of that charge, sir?
I do.
That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that, sir?
I do.
All right. First question I have for you is, do you want to be represented by an attorney?
I do.
Okay. Sounds like he's at a wedding. All right, this is a public defender case.
Assistant Public Defender Natalie Pitts, on behalf of Mr. Brand, we would waive any further reading of the complaint, stand mute, and ask for an adjourned pretrial date, please.
And in every way, formal reading, standing mute, court will enter not guilty plea. Pretrial in this matter will be adjourned to September 17th, 2025, 9 a.m. where your invite indicates. As to bond in this case, I'll set his bond at a $5,000 personal recognizance bond. Sir, I'm going to order standard conditions, including no assaultive behavior or possession of any weapons. You understand that?
Yes.
I'm also going to indicate that there's to be no possession or consumption of any alcohol, recreational marijuana, or any illegal drug. Do you understand that, sir?
Yes.
I'm also going to, you are not to have any contact with Elton Ford. Do you understand that?
Yes.
Anything else?
No, Your Honor, thank you.
No? Thank you, sir. Thank you.
Thank you, Your Honor.
All right, that's my 9 o'clock. 10 o'clock, is the jail up yet?
They are.
Okay, let's get everything organized, get them going. The court's going to take a very brief break and then I'll come back and we'll continue to go. Court's in recess. All right.
All rise. 14A District Court of County of Washington Office Division is now at session. The honorable
May be seated. Court does call the case of the people versus Abduram Banda.
Have both the people.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Banda. Mr. Banda, please state the record.
Observe, Mr. Brenda.
Your Honor, we are here for a pretrial. I guess our request is to adjourn the pretrial, which is kind of connected to the bond violation.
Yes.
The bond violation report alleges that Mr. Banda had positive alcohol blows. I did speak with him and advise him he had a right to a hearing. He does not want a hearing and he wants to admit to the violation.
Is that correct, sir?
Regarding the pretrial, the reason for the adjournment is Ms. Feltus and I did confer about this case. We are going to request that Mr. Banda be released to treatment, inpatient treatment, given the alcohol use in the underlying case and these and this bond violation.
I will sign an order releasing the treatment if I'm presented with one, so that's not a problem.
And now we'll get that into the court.
All right. And then you just need an adjournment of this date?
Yes.
Adjourn this to September 17th, 2025, 9 a.m. How long has he been in?
He was in for a month before the violation and then got out, was picked up. He's been in for a week at
this point.
At this point, since he was picked up.
What do I have as bound up?
Or to be clear, he did report to community corrections when they told him to after the positive blows.
I think it was denied.
Yeah, I think his bond at this point is denied. Well, I'm not going to consider anything at this time, but what I will do is
Simple. I only pay $10 a month for my internet connection. Fast, unlimited, anywhere. Have you heard about Rio?
I'll set his pretrial and sentencing on the bond violation for the 17th. At that same time, I'll set his bond this time at a $25,000 cash bond.
Thank you, Your Honor.
Thank you.
Thank you.
Thank you. Wow. Court does call the case of the people versus Matthew Bullard.
I should spell this for the people.
This is a show cause, Your Honor.
Show cause. Off of that, they're not here. Matthew Bullard, no response. Bench warrant will issue for defendant's failure to appear. Bond will be set at $5,000. I think a 10% privilege on that. That warrant will issue immediately. Court calls case of the people versus Dion Covington.
Conrad Solar on behalf of Pittsfield Township.
Good morning, Assistant Public Defender Lauren, on behalf of Mr. Covington. Say your name for the record, please, sir.
Yeah, Covington.
Your Honor, regarding the underlying case, we have come to resolution. Mr. Stiller has extended a plea of or offer of double parking on the possession of drug paraphernalia case. Mr. Covington is on probation at 14A2. There he was sentenced to 365. And his probation was revoked with a release to treatment. So once this case is resolved, the hope and the plan is that he'll be released to get assessed and get released to treat inpatient.
So it's double parking. Is that correct, Mr. Stiller?
That's correct, Your Honor. So I move to add count 2 of double parking. And of course, if you accept that admission, move to dismiss the original charge.
All right. Mr. Covington, do you admit responsibility to the fact that on or about June 23rd, 2025, Carpenter Road, Pittsfield Township, that you double parked a motor vehicle?
Yes, sir.
All right, court will accept that admission to count 2. Count 1 is dismissed. Fines and cost, $180. That will be payable 90 days after release. Thank you. Case people versus Deanna Conrad.
Conrad Solar on behalf of Pittsfield Township.
The Assistant Public Defender, Natalie.
Well, that's it for today, ladies and gentlemen. I will see you tomorrow at 3 o'clock for, let's see, Judge Boyd, Judge Stephanie Boyd's docket. So you all have a wonderful evening, and God bless, and I will see you soon. Bye-bye, ciao, ciao, and ta-ta.
You know how to man all my scattered seams with your steady hands.
You're my solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time.